Right, good afternoon, everyone, and welcome to SIAC's webinar session on frustration on force majeure and the early dismissal application under Rule 29 of the SIAC Rules. We're very glad this afternoon to have an extremely good attendance from all over the world. I'm told that we have over 800 participants who have signed up. And from 20 over almost 30 countries, with some participants from the United States. And at this time of our day and this time of your night, it's probably either 1 a.m. in the morning or 4 a.m. in the morning, depending on which coast you are residing at. So we thank you all for the support and for the interest in the topics which are under discussion this afternoon. And certainly, I think we are all living through extremely unusual circumstances, very challenging for some of us, especially in some countries which are struggling now with still the impact of the virus and its influence and impact on commercial and economic activity. And as lawyers, we are really at the forefront of helping some of our clients through these uncertain times. So this is a very timely topic and very relevant and very current in this time. And I'm very happy this afternoon to have the expertise of 5 of my colleagues from a couple of jurisdictions. I'm very happy that they are able to join us this afternoon. Mr. Simon Chapman, Queen's Counsel, Mr. Chan Ling San, Senior Counsel, Mr. Hee Teng Fong, Mr. Chao Li Jin, and Mr. Arthur Dong. We will be going through some of the principles of frustration and of force majeure in both civil law as well as common law jurisdictions. And then we will be discussing how Rule 29 of the SIAC Rules, which prescribes the protocol and the regime for early dismissal, may be invoked, and whether they could be invoked for frustration and force majeure situations. Now, the speakers will be taking a short bit of time to present their respective points, and some of these presentations will be accompanied by PowerPoint slide presentations as well. There is also a function, and I'm still learning to grapple with all of these functions which are available on Zoom, where you could submit your questions. We will try to take as many of the questions as we can. But given the fairly limited time that we have to deal with both the presentations as well as the questions, we probably will not be able to handle many questions live in the course of today. But what we will try to do is that we will seek to put together the answers to as many of the questions as possible. And then through SIAC, we are going to make available the questions and the answers submitted by the participants and make it available to the rest of you. Right? So do send in your questions as the presentations go on. We will only be able to deal with a selection of them, but not to worry, we will try to deal with as many of them as possible in the course, if not in the course of today's presentation, then certainly in the course of the next few days, we'll try to get all the answers going over to all of you, the participants. Right, so without much further ado, it is my privilege to call upon first Simon to give us, share with us some of his thoughts on frustration, on the doctrines of frustration and force majeure in a common law jurisdiction. Simon really needs no introduction. He leads the Greater China Disputes Practice at Herbert Smith Freehills. He's based in Hong Kong and focuses on international arbitration. He's qualified in England and Wales, and Hong Kong, and has advised a number of clients in China and the wider region on claims arising from the COVID-19 pandemic, including issues of force majeure and frustration. So, ladies and gentlemen, my pleasure to call on Simon Chapman, Queen's Counsel, to give us his presentation. Simon, please.
Thank you, Wee Ming, and good afternoon to everyone. It's great to have so many people that have joined the webinar this afternoon, and I'm delighted to speak to you all from my office in Hong Kong. As Wee Ming mentioned, I'm going to cover, really as an overview, the two concepts of frustration and force majeure under common law systems, so general principles that apply in most common law jurisdictions where there are some important differences to the treatment, especially of force majeure in civil law systems. So if we just start with the first slide of the presentation, I've set out here just some basic concepts, some key concepts in relation to both force majeure and frustration. And you'll see from the bullet points at the top of the slide that they both concern supervening events. And what is a supervening event? Well, it's anything that happens after the execution of the contract, which is outside the control of the parties, but which affects performance of the underlying agreement. The key difference between them, and the most important takeaway really for the purposes of this webinar, is that in common law jurisdictions, frustration is a legal principle. It is something that operates as a matter of law to bring the contract to an end, usually where performance has become impossible as a result of a supervening event. So it is a fundamental legal principle in common law jurisdictions. Force majeure is a contractual clause. It's merely a label that is given to a particular clause in a contract that seeks to deal with supervening events. And the usual effect of force majeure when it's successfully invoked is that it suspends performance of contractual obligations. It doesn't usually terminate the contract, or at least not immediately. And so because force majeure is not a term of art, it's a contractual label, it can mean whatever the parties define it to mean. It doesn't have a fixed meaning in common law jurisdictions. And that's very different, for example, to the position in mainland China. And I know some of my colleagues on this webinar are going to address the PRC law position. But force majeure isn't a separate legal principle in common law jurisdictions. It's just a convenient label that parties give to a particular type of contractual clause. And so for that reason, if you say in your contract that the legal force majeure clauses apply, that will not be an enforceable obligation in most common law jurisdictions, because the term force majeure in and of itself is meaningless. It means whatever the parties say it means in a particular agreement. So just moving then to the next slide and looking specifically at frustration. Frustration is generally a very high bar in most common law jurisdictions. It only applies in exceptional circumstances, and it usually very difficult to establish. The basic principle is that the supervening event must render performance of the contract impossible, or at least radically different from what the parties had originally envisaged. So you can see it's a very high bar. It has to be something that goes to the very root of the contract and therefore makes the entire bargain something entirely beyond what the parties had originally envisaged. And another important point in relation to frustration is that it will only apply in circumstances where the parties have not already made some provision in their contract for the allocation of risk in the event that a supervening matter arises. And so you can see, therefore, that there is potentially some overlap between force majeure and frustration, because if you have a very comprehensive force majeure provision in your contract that deals with all sorts of different eventualities, it's less likely that frustration will apply. It's less likely that the courts will come to your assistance. And I've given some examples on the next slide of when frustration might arise. You can see that these are all very old cases under English law. Some of them are almost 200 years old because this is a very settled principle of law. And these are all cases as an English law student that you learn when you're at law school. I'm not going to go through each of them in turn, but just to give you one example, the Taylor and Caldwell case was about an agreement to rent a music hall for the purposes of certain performances that were to be given. And after the contract was signed, the music hall burnt down. So the very subject matter of the contract then ceased to exist. And in that extreme circumstance, the court said that it would intervene and it would find that the contract had been frustrated. It was immediately brought to an end, and both parties were therefore released from their existing liabilities, their existing obligations. The NEMA case, which is the last bullet point on this slide, is also interesting because this deals with a prolonged strike that went on for several months and prevented a charter party agreement from being performed. And in that situation, the court did find that the contract had been frustrated. But I mention it only because in most modern contracts, things like strikes and trade disputes are generally covered in a force majeure clause. If you've got a boilerplate force majeure provision in your contract, it will ordinarily cover things like strikes and trade disputes, and it will say exactly what is to happen in those situations. So in most contemporary agreements, you wouldn't find a case like the NEMA where you have to rely on frustration because you will already have your force majeure. Turning then very briefly to force majeure on the next slide, as I said, it really depends on what words you've used in the contract. And I've given you here on this slide an example of what a modern force majeure provision might look like. It covers all sorts of acts of God, floods, droughts, earthquakes, etc., etc. And you can see within that clause also the reference to labour or trade disputes and strikes. One thing that's quite interesting is that a lot of force majeure provisions don't cover epidemics or pandemics. You do occasionally see that wording used, but it's not in a lot of boilerplate contracts. And so an important issue at the moment is whether COVID-19 is a force majeure event under certain agreements. Could you say, for example, that it's an act of God? Very unlikely, I think, that that sort of argument would be successful. So it's an important point. You have to get your drafting right in the agreement. You have to make sure that it is all encompassing. The FM clause will usually require that the supervening event either hinders or delays performance of the obligations, or it may say that you can only rely on force majeure if it prevents performance, so it makes performance impossible. Again, it's all down to the specific words that you use. And very often force majeure clauses include exceptions, so they will say very frequently that a party cannot rely on force majeure simply because there's been a change in economic conditions which have rendered performance of the agreement less profitable for one side. Then you can see immediately that that is likely to be a key issue in relation to COVID-19. Just because there's been a collapse in demand for a particular product doesn't necessarily mean that that will fall within the scope of force majeure. Very often that risk is carved out of the agreement. And then finally, on the last slide, I've just listed some practical considerations for you to consider in relation to force majeure and frustration. Generally, if you're faced with a supervening event, it's better to look at the force majeure provisions in your contract first to see if you can seek relief in relation to FM. Only consider frustration if you're confident that force majeure doesn't apply, because the bar in relation to frustration is so much higher than relying on force majeure under the contract. Very important, of course, to consider the nature of the supervening event. Does it fall clearly within the scope of the force majeure clause, going back to the point I made a few moments ago about epidemics and pandemics? Does it prevent performance, or does it just make it more difficult? What's the specific hurdle that you need to meet under your agreement? And are there any exceptions which you need to be aware of? And then finally, most force majeure clauses in modern contracts have quite detailed notice provisions. They say, if you want to rely on force majeure to excuse performance, you've got to give a formal written notice within a particular period of time. Often you're required to certify the relevant force majeure event. So very important to have regard for the provisions of your contract and make sure that you pull all of the levers in the contract properly if you want to rely on force majeure. And then if that's not available for whatever reason, can you rely on frustration, recognizing, as I said earlier, that it is quite a high bar under most common law jurisdictions. So that was all I proposed to say, just by way of a brief overview of those two concepts. I'm very happy to answer any questions at the end of the webinar if people have questions that they want to ask. Thank you.
Well, thank you very much, Simon, for that very enlightening presentation. And I think it sets out very clearly and succinctly the main points in relation to both force majeure clauses as well as frustration, that they're both supervening events. And I think, as some people would sometimes refer to it, the force majeure refers to a supervening event which is foreseeable or which parties have provided for in their contracts, and frustration would refer to unforeseeable event, but which nonetheless intervenes to disrupt the performance of that contract. That last question which you posed, if force majeure is not available, can you rely on frustration, is interesting. It may have implications on what we are facing right now. If a party is stopped from performing his contract, it may not be force majeure, but can it be frustration? I think it opens up interesting legal questions and certainly possibilities for discussion. The later point of our seminar this afternoon. But right now, I'd like to invite Mr. Chao Li Jin from Zhonglun to give us his perspective on force majeure and frustration under the civil law jurisdiction in China. Li Jin is the co-head of Zhonglun's dispute resolution practice, and he practices law. He's licensed to practice law in China and in New York. And before starting private practice, Li Jin worked with SIAC for many years. Among his professional affiliations, Li Jin is an arbitrator of SIAC, HKIAC, SIAC, AIAC, ICDR, WIPO, CMAC, and KCAB. He's also a member of the SIAC Court of Arbitration, SIAC Court of Arbitration, a member of the CRC ICA Advisory Committee, and the Vice Chairman of the Arbitration Committee of ICC China, and the Secretary General of the Arbitration Committee of ACLA in China. He has represented clients in over 200 arbitration cases and a key member of the legal team that successfully defended the PRC government in an exit case. So I'm pleased to call upon Li Jin to give us his presentation. Li Jin, please.
Thank you, Wei Ming, for the kind introduction. It's my pleasure to join my colleagues and everyone through the video link. Simon already mentioned that in civil law jurisdictions, including China, there are different provisions on different practices on force majeure. It's indeed true that in China, the mechanism on force majeure are different. The primary difference is that we do have a statutory force majeure. So the definition of force majeure is clearly set forth in PRC civil law general provisions as well as in PRC contract law. Because most of our cases are contractual disputes, so probably need to focus on the relevant provision of PRC contract law. The definition is to be found in Article 117 of the PRC contract law, which says that force majeure means any objective circumstances that are unforeseeable, unavoidable, and insurmountable. So those are the three requirements in order for a force majeure to be found to exist. Article 117 also provides the general effect of force majeure, which is exemption of liabilities. It says where a contract is not able to be performed due to a force majeure, the liabilities shall be exempted in part or in whole in light of the effects of the force majeure, except as otherwise provided by law. Article 118 of the PRC contract law also deals with force majeure, but mainly a provision on the notice to the counterparty in case of a force majeure event and the certification of a force majeure event. My understanding is my colleague Arthur Dong will cover those points, so I will just skip those points here. You may wonder what are the effect or the nature of a force majeure provisions under PRC law. The common view of scholars as well as practitioners in China is that force majeure provisions in the PRC contract law are mandatory in its nature, which means that parties to a commercial contract cannot opt out or contractual out of the statutory mechanism of force majeure by saying that they will need to perform the contract, a party will need to perform the contract and assume liabilities despite occurrence of any force majeure circumstance. Having said that, I must say it's also very popular to see FM or force majeure clauses in commercial contracts. In some industry, for example, for oil and gas, the energy sector in general, force majeure clauses are carefully drafted and negotiated. I have seen force majeure clauses as long as 5 pages or 9 pages long, which shows that companies attach a lot of importance to this clause, and there must be a process for careful drafting and negotiation. More often than not, there is always a non-exhaustive list of events or circumstances that should be deemed as force majeure events in such a clause. You may wonder what is the interplay or interrelationship between statutory force majeure provisions and force majeure clauses in a contract. So the common view is that force majeure clauses are to be examined from the perspective of statutory requirements in the Chinese law. In other words, in order for a listed circumstance in a force majeure clause in a contract to constitute a force majeure event under Chinese law, it needs to meet the definition in Article 117 of the PRC law, as I said, unavoidable, unforeseeable, and insurmountable. However, as long as a circumstance is listed by the parties in a force majeure clause, it's my view that it's not unavoidable. I like the saying by US Professor Berman that in a commercial transaction, nothing is unforeseeable. I agree with that. But most of the experts or scholars in the industry in China, their view is that foreseeability or unforeseeability goes to the reasonable person in the shoes of the contracting parties, not the contracting parties themselves. That means to say there needs to be an objective test rather than a subjective test when as soon as unforeseeability is to be observed or examined. In case the provisions on force majeure in a contract do not meet the requirements in the Chinese law, what's going to happen? So the mainstream view is that they will be categorized not as force majeure events, but rather exemption events or exemption clauses, which means parties' intention for exempting a party of its liability for non-performing the contract or contractual obligations will still be respected, but it's under another category. Exemption clauses are also clearly provided under PRC law, and there are limitations. For example, in Article 54 of the PRC contract law, exemption clause will be deemed as invalid if it exempts parties' liability from causing personal injury or causing property loss by intention or by gross negligence. So there are limitations. But for force majeure, there are no such limitations. Having said above, I think in practice, force majeure clauses are very popular, as I said, and the circumstances listed in a force majeure clause are generally respected. I personally never came across a situation where a force majeure clause in a contract has been successfully challenged in the context of arbitration by myself. So I have no idea whether the other colleagues have a different experience. Let's take a closer look at the statutory requirements. Unforeseeability, as I said, should be observed from the perspective of a reasonable person. There is an objective test. There is also a time element, which means it has to be referring to circumstances after the contract is concluded. If, for example, I've seen a few such cases, a foreign company signed a contract with a Chinese producer of medical masks. If that happens in November last year, the COVID-19 epidemic or pandemic will be deemed most likely as a force majeure event. But if the contract is signed, for example, in March, the producer can hardly rely on the force majeure clause in the contract to avoid liability for non-performance of its contractual obligations. Unavoidable and insurmountable, those two elements should be assessed from the perspective of the parties to the contract. Between the two, unavoidable relates to the occurrence of the force majeure event, and the insurmountable relates to the effect of such an event. According to Article 117, also, if the force majeure occurs after one party has delayed its performance, then the liability of the party shall not be exempted. The rationale for this provision, in my understanding, is that the force majeure event could have been avoided had there been no delay in performance. Thus, there shall be no exemption of liabilities for non-performance. Insurmountable means that the consequence of the force majeure event cannot be overcome. The medical mask case, if the producer cannot manufacture or deliver the goods on time because certain materials are more expensive than before, then it's not something insurmountable. If you seek a remedy, that's another topic. Article 117 also talks about the event or the contract for not being able to be performed. There is a range of possible meanings for this language. Within the range, there is an impossibility to perform the entire contract, the impossibility to perform part of the contract, or impossibility to perform on time. So correspondingly, the remedies that the non-performing party may seek will be full exemption for performance, or partial exemption for performance, or delayed performance itself. So this is consistent with Article 94 on rescission of the contract. One of the circumstances that a party can seek rescission of a contract under Chinese law is that there is force majeure, and because of force majeure, the purpose of the contract cannot be fulfilled or achieved. My understanding is that exemption in part or in whole, this is in contrast with the common law mechanism, whereby under the doctrine of frustration, it's all or nothing. So you cannot seek partial exemption. That's something I understand from my reading of the relevant material, as well as from Simon's presentation. Thank you. I conclude my comments under this topic. Ming?
Yeah, thank you very much, Li Jin. Now I move on to Arthur and invite further comments from Arthur Dong on these doctrines under Chinese law. Arthur has worked as a PRC lawyer for more than 20 years, focusing on complex international commercial arbitration and litigation in relation to cross-border transactions. And his expertise covers a broad spectrum, including cross-border investments and M&A, international trading, technology transfer, and intellectual property protection, as well as distribution and franchise disputes. He has been acting as legal counsel or arbitrator under SIAC Rules, ICC Rules, HKIAC Rules, ICDR Rules, and UNCITRAL Rules. And he has been invited to act as an expert witness on Chinese law in several arbitration and litigation cases, both in and out of China. And so it's my privilege to call on Arthur to give us his comments. Arthur?
Thank you, Wei Ming. I would like to give supplemental remarks on this force majeure topic from 2 points. The first point is about the certification of force majeure. First of all, I would like to share a real case that before SIAC, we represented a Chinese bank, and the respondent is a seller from Russia. We claimed damages from the non-performance of the contract, but the Russian party submitted to the tribunal a document named Certificate of Force Majeure. It's rendered by a Chamber of Commerce of Russia. The certificate saying that the respondent is affected by the government order, which is a force majeure. So he is not responsible for the non-performance of the contract. And that case was settled before the hearing on the merits. But I'm doubting that how the Chamber of Commerce can give a certificate saying that that kind of event, that kind of government order is legally force majeure, and that party was could escape from obligation of performance. It's true that in recent days, due to the impact of the pandemic, it's reported that many Chinese companies went to the Chamber of Commerce asking for a certificate of force majeure. So they may think that they could be found not reliable, not responsible for the non-performance by showing that certificate to the tribunal by the end of the day. But I would like to say that the certificate of the Chamber of Commerce could only prove a certain kind of fact. For example, the order of the government for the shutdown of the airport or the stop of the transportation. But whether it could be defined as a force majeure, it will be subject to several other factors. For example, what stipulation of the contract was a governing law, and more importantly, maybe the most importantly, the causation before the fact For example, the order of the government due to the pandemic and the non-performance. So it's not by that help of the document, the company could be escape the duty of performance of a contract. Second point that I would like to share is that just in last month, the Supreme Court of China published guidelines for the lower courts of how to deal with the civil and commercial disputes related to the pandemic. By that kind of opinions, the Supreme People's Court of China give the lower courts some guidance that how to apply the doctrine of force majeure in the real cases. In what circumstances that the contract could be terminated, and in what circumstances that the contract could not be terminated, but only be modified. For example, if the fact affect only the performance of the contract, but only the difficult, make the contract more difficult to perform, but the contract could still be performed. So the Supreme Court would like to say it could not be terminated, but only could be modified. This guiding opinions, I believe, will have influence even on arbitration, where the Chinese law being the governing law. Due to the time limitation, I would like to just share the remarks from these 2 points. Thank you, Amy.
Thank you very much, Arthur. Very pleased now to call upon Ding Fong. Ding Fong has been working on arbitration matters involving Chinese parties, and in fact on cases where Chinese law is involved. And I thought that at this point in time it's good to route this over to Ding Fong so that he could share with us some of his thoughts and observations as he deals with cases as an arbitrator involving Chinese law. Ding Fong is an experienced arbitrator. He's handled a couple of 100 cases in civil litigation and international arbitration as lead counsel or as arbitrator. And many of these cases are reported in the Singapore Law Report and Journals. He's written arbitral awards in both English and Chinese under various international arbitration institutions, including SIAC. He has heard cases on force majeure as an arbitrator, and he will share with us the differences between Singapore and PRC law in respect of force majeure, and also bring to us the benefit of his experience as an arbitrator, hearing at least one of these cases involving force majeure under Chinese law. Right, Ding Fong?
Everybody, I would, can I just make sure that you all can hear me? Yes. I would say briefly what I understand to be the legal principles governing force majeure and frustration. I will start with common law and then move quickly into a comparative study between Singapore law and PRC law in this area. Simply put, force majeure when certain stipulated events occur, a contractual obligation is suspended or discharged. Under frustration, when certain changes of circumstances occur, a contract is discharged. On the second slide, you can see that frustration applies by operation of law because the law regards the change of circumstances as so different that the contractual obligation cannot be performed. The ambit and effect of every force majeure clause differs from case to case, and it is a matter of interpretation of the wording of the force majeure clause. You can see on slide 3 a list of cases in support of what I have said earlier. In slide 4, you can see that one of the commonly asked questions is whether the triggering event must be reasonably foreseeable. The doctrine of force majeure clause may not apply if the event, the doctrine of force majeure and the doctrine of frustration and the force majeure clause may not apply if the event is reasonably foreseeable. So on slide 5, you can see that, for example, in one of the English cases, the possibility of enough labor and materials not being available was reasonably foreseeable. This possibility of shortage of labor and materials was before their eyes and could have been the subject of special contractual stipulation. It was not made so. The English court held that the contract in question was not frustrated. Reasonable steps. You can see from slide 6. Must the affected party take reasonable steps before it can invoke force majeure? The answer is that there is no blanket principle. But where the clause concerns events beyond control, what you can see on the slide here is an extract from a judgment. In short, if you have not taken reasonable steps, how would you know that the event is beyond control? This approach resonates with the principle under the doctrine of frustration that there can be no self-induced frustration. Put differently, in order for the doctrine of frustration to operate, neither contracting party is at fault. In the next slide, slide 7, let me show you a common standard force majeure clause. A similar clause appeared in one of the arbitration cases of which I am the arbitrator, or one of the arbitrators. It's an SIAC case. The governing law is PRC law. The factual background is that there has always been an existing regulation, but companies in the industry seldom complied with the regulation, and it was not strictly complied with. After signing the contract, the regulation was enforced more strictly. One of the parties would then have to incur much more cost in performing the contract. In slide 8, the question in this case, one of the questions in this case is this: is a strict adherence to an existing regulation which was never seriously implemented a foreseeable event? You put yourself in the position of, I think you need to go back to the slide on, yes, that's right. So you put yourself in the position of the counsel or the arbitrator. If the existing regulation has not been implemented for years, would you reasonably foresee that it will be implemented? Or is the implementation itself the force majeure event, or the risk of it being implemented, the force majeure event? So the tribunal members will have to consider this as one of the issues. Just to share with you some of the thoughts in relation to this case. So you can see from slide 9, is higher cost a force majeure event? In one of the Singapore cases, the increase in customs duty and inflation taken together or singly did not prevent the party involved from performing the contract. They only made the performance of the contract more expensive and costly, but that is not force majeure. The court also held that though the profitability is lower, that is not frustration. So in slide 10, you can see that it is not hardship or inconvenience or material loss itself which calls the principle of frustration into play. In this case, Davis Contractors Limited, the contract in question was supposed to be completed within 8 months, but it was delayed due to shortage in materials and labor. It was completed in 22 months, a delay of 14 months. You ask yourself the question, is this an obligation that is totally different from what was originally undertaken? This case went all the way up to House of Lords. The House of Lords held that there is no frustration. The next slide is causation. If you recall, the case that I heard as an arbitrator, the word due to appeared in the force majeure clause. So the question is this: a stipulated event has occurred, but is it due to this event that you are unable to perform your obligation? Is there any causative link between the event and your inability to perform the contract? So you can see me moving from Singapore law to the case I heard in relation to PRC law. I will now give us a brief comparative study between the two concepts in the Singapore law and PRC law in respect of force majeure and frustration. Under slide 12, you can see what Cao Lijun has mentioned earlier. PRC contract law, Article 117 and 118. So the question to be asked, similar to what Lijun has posed earlier, is whether the three elements, unforeseeable, unavoidable, and insurmountable, are disjunctive or accumulative. Must the party asserting force majeure satisfy all or just any one of the three elements? And if you look at Article 118, the question is whether the failure to give notice under Article 118 is fatal. Lijun touched on contractual interpretation. Yes, a contractual force majeure clause applies. Whether it applies or not is a question of interpretation. In PRC, how a contract is to be interpreted is governed primarily by Article 25, among others, of PRC contract law. Now, whether a tribunal would adopt the principle of contextual interpretation or textual interpretation, the law is still evolving in PRC. In Singapore, we have Zurich Insurance, Sembcorp Marine, Xie Zhengyan, and Yap Sut On as key cases in this area. Of course, I think it may well call for another forum to discuss this interesting topic on contractual interpretation. Now, on the change of circumstances, you can look at slide 3. The concept of change of circumstances in PRC law is similar to the concept of frustration in common law. If you look at Article 26 of interpretation number 2 of the SPC or PRC contract law, you can see that where the major change is unforeseeable and is not a business risk and is not caused by a force majeure, occurs after the formation of the contract, and it is obviously unfair to the other party or cannot realize the purposes, then the People's Court shall decide whether to modify or rescind the contract. It's similar but not identical to the common law concept of frustration. In fact, to a large extent, it is premised on the assumption that force majeure and change of circumstances are triggered off by different events. So if you look at it in the context of common law, in David's case, the 8th month, you look at slide 14. In David's, the 8th month contract was delayed by 14 months due to shortage in materials and labor. The court in UK said the doctrine of frustration didn't apply. In the context of PRC law, is this an obligation that is totally different from what was originally undertaken, would the same conclusion be held under PRC law under Article 26 of SPC Interpretation Contract 2? Would it be obviously unfair to the other party, or as a result of change of circumstances, the purpose of the contract cannot be realized? So these are all interesting questions. Of course, you can have experts on PRC law to enlighten us on this. With that, I move on to COVID-19. If you can look at slide number 15, the question, of course, is whether COVID-19 is foreseeable. After the SARS in 2003 and H1N1, could you still argue that COVID-19 is not foreseeable? And is epidemic the same as pandemic? Is it an act of God? Does breakdown of supply come within COVID-19 pandemic? Does COVID-19 come within the meaning of any other event beyond the control of the parties? The answers to these questions depend very much on the actual wording of the clause involved and the facts in each case. And it would be fair to say that the above factors and questions would be taken into consideration by counsels and tribunal members. This is what I have to share with you at the moment. I'll be pleased to take questions later on. Thank you.
So thank you very much, Ting Fong, for sharing your points and in relation to the case that you did, where you had to apply Chinese law to the concept of frustration and force majeure. And the questions which you posed at the end of your sharing, whether or not these circumstances that we are in right now, whether COVID-19 actually would present itself as an event of frustration or whether even as a force majeure event. I mean, obviously, it will have to depend on whether in the first place, in order to qualify as a force majeure event, whether it is even a contractual provision there. But as to whether or not it may constitute a frustration, an event of frustration, that's interesting, because one of the questions I see that's been submitted to us, and I can understand and perhaps identify with the quandary that this particular participant is in. He says that he's a subscriber of the English Premier League package, the EPL package, and he signed a 12-month contract commencing August 2019, which allows him to watch all the weekly English Premier League games live. And the English Premier League season has been suspended indefinitely since mid-March 2020. But actually, I think there are some good news here. Incidentally, I think they may be coming back on in June. That's what we hear. And would this qualify as a frustrating event such that I'm discharged from my contractual obligations, namely to pay for the remainder of the contract for as long as the EPL does not resume? It's an interesting question, which, I just want to maybe throw this up to a couple of my panelists. Very short answer what you think the situation might be. I can tell you this. My wife is also very interested to know. She's been blaming me for signing up on a contract, which we are deriving absolutely no benefit from right now. So just to see whether any of my panelists would want to hazard a guess on some of the principles. I don't think we can advise you on whether you can sue your the person who sold you this package. That depends on the facts. But obviously, I think one or two considerations that we may want you to take note of. First, perhaps Simon, just any short words of wisdom on this?
Sure, it's a very interesting question. I think I would be very surprised if this sort of eventuality were not dealt with somewhere in your contract with Singtel. Very often in these sort of subscription agreements, there's lengthy boilerplate provisions in the small print that set out what is to happen in this type of scenario. And obviously frustration cannot apply if the parties have already contemplated this sort of eventuality in the contract. So my gut instinct is that you couldn't argue that the contractor is frustrated, because I would imagine that there is something somewhere in the small print that Singtel would be able to rely upon to say that this sort of thing has been contemplated, and that you remain on the hook to pay your subscription fees, even if the Premier League is not available for a certain period of time. That said, if the games are cancelled for the full 12 months, maybe your argument is a bit stronger. But if it's a limited duration, I suspect it's already dealt with in the contract.
Thanks very much, Simon. That's pretty bad news for my wife. Would you like to maybe weigh in on this?
Okay, I think it depends very much on the exact wording in the contract. But to say that this is not a foreseeable event, it is a difficult argument, especially in the context of a 12-month contract. And to say that this event, COVID-19, would eradicate the whole period of 12 months, it is a challenging argument.
Right. Okay. Thank you very much. Not just Simon, if you could quickly give us some of your thoughts on this question which came up, to explain the interplay between force majeure, frustration, material adverse change, and the contract all risk insurance if a party has the option of more than one of these in a contract.
Yeah, and again, the answer will depend to some extent on the specific wording that's used in the contract, especially when you're looking at force majeure, because, as we said throughout the webinar, force majeure in a common law system is really a creature of the contract. It is what the parties define it to mean. So the circumstances in which that will apply will vary from case to case. But generally speaking, those provisions are all dealing with slightly different things, albeit that frustration and force majeure are both intended to address supervening events. Frustration, generally very high bar. You can only invoke that if you have no other remedy in relation to force majeure, for example. So there's a clear separation between those two. If you've got force majeure in the contract, you will only be able to invoke frustration if the supervening event falls outside the scope of that clause, because as Bi Meng said earlier, frustration is dealing with truly unforeseen events, whereas force majeure clauses are seeking to allocate risk depending on certain events which might be foreseen at the time of contracting. And then a material adverse change clause, again, it will depend on the specific contract, but usually those are aimed at slightly different circumstances. So material adverse change clause, you see this very often in sale and purchase agreements, for example, are intended to deal with what happens if there is a substantial shift in the fortunes of usually the asset that is under consideration, the asset that is being sold. For example, if it shares in a company, what happens if the financial position of the company deteriorates dramatically within a period of time? There isn't a huge amount of case law actually on MAC clauses, surprisingly, given how frequently you see them in agreements. But they are generally only invoked in quite extreme circumstances. There has to be some fundamental shift in the subject matter of the MAC clause. But again, it's dealing with something slightly different to force majeure and frustration, which affects really the entirety of the obligations under the agreement. I hope that's helpful by way of a brief explanation.
Right. Thank you very much, both Ting Fong and Simon, and also to Li Jin and Arthur for sharing your thoughts. We move on to early dismissal procedures under SIAC rules at Rule 29, and we'll have Ling San to share with us his thoughts, his views on that interesting topic or that procedure. Ling San is independent counsel and arbitrator with Essex Court Chambers, Duxton, and he is deputy chair of the SIAC. So if there are any good feedback or any unhappy pointers about this afternoon seminar, please refer to Ling San and not to me. And he's also the former president of the Singapore Institute of Arbitrators and the former global head of arbitration of Baker McKenzie. All right, so my pleasure now to call upon Ling San to share with us on Rule 29 of the SIAC rules. Ling San.
Thank you very much, Wei Ming. We now take a break for a few minutes from force majeure and talk about some procedures in the SIAC rules. And later you might want to consider them in the context of the general theme we're talking about. The early dismissal provisions in the SIAC rules were introduced in 2016, Rule 29. I will show them to you in a minute, but the idea is that a party may apply to a tribunal for early dismissal of either a claim or defense, rather than have it go all the way to a full hearing, especially an evidential hearing. And you can do so on the basis that the claim or defense is manifestly without legal merit, or that it is manifestly outside the jurisdiction of the tribunal. Now, for those of you who operate in a common law jurisdiction, you may think that there's nothing much to this. It's really not novel, because in court, in a common law court, you do have summary procedures. For example, striking out of the claim or striking out of part of the claim pleadings, whether it's in the statement of claim or defense. Or you also have the Order 14 procedure for summary judgment or summary determination. But why did it take so long for an arbitral institution to introduce this provision? There had been some resistance from the arbitral community to the idea of a summary dismissal. A lot of those who were against it felt that it was against the culture and context of arbitration. In fact, this was one of the conclusions made by an ICC task force in 2007, who recommended against having explicit summary dismissal provisions in the ICC rules. They felt that it would open the door to a party, a dissatisfied party, to challenge the award if they were not given their full opportunity of presenting their claim or their defense with a full hearing and so on. Some concerns were also expressed that if you allow this additional procedure, it might be abused as well, and it could be used to harass the claimant, for example, or the respondent, by having this additional step, whether or not they have merits in it, and it could ultimately add to the cost of arbitration rather than minimize the cost. But the proponents felt that this is a necessary procedure, because if the case is obviously bad, whether it's your defense or your claim, why should parties go through the whole process and have the arbitration being drawn out all the way to a full hearing at the end? So they felt that it is ultimately in the interest of saving time and cost that arbitral institutions should allow for this kind of procedure. In fact, even before this provision was put into place by SIAC in 2016, there are similarities, but some tribunals, as you know, will allow bifurcation of issues and render preliminary awards or interim awards on certain issues, for example, on liability, and then you decide to go on for quantum if you win on liability. And even in ICC arbitrations, despite the opinion of the task force, some arbitration tribunals under ICC, as long ago as 2001 or 2002 or 3, had actually taken on themselves the inherent power of summarily dismissing a claim on the basis that it's part of their case management powers under Rule 22. So there had been all these differing opinions, and some tribunals have been more robust than others. But in 2016, SIAC decided to adopt this procedure, and I will show you the wording now by sharing my screen. If you look at the wording, you can see that it provides for the tribunal to dismiss a claim or defense on 2 grounds. One is that the claim is manifestly without legal merits, or 2, that is manifestly outside the jurisdiction of the tribunal. Now, did SIAC just come out of this and pluck them from the air? No, because the idea for this had already been implemented in 2006 by ICSID. And as some of you may know, exit is the separate regime for investor-state disputes. So the exit rules, which are administered by the World Bank and by exit in particular as part of the World Bank, in 2006 decided that they should have this process for summary dismissal, and they incorporated that into the exit rules in 2006. Now, with the concerns by end users, especially getting more vocal in recent years, that arbitration has become too expensive, too complicated, and it's taking too long, I think support for summary dismissal has grown. And the SIAC summary procedure in 2016 actually is not considered controversial at all. In fact, in 2017, ICC also amended its practice note to provide that a tribunal does have the power for summary determination. They put it in the practice note, and they explained that it's also part of the tribunal's powers under Rule 22, Article 22 of the ICC rules. So there you have it. You have these provisions. And if you're talking about how would this apply and what is meant by that, there is certainly enough body of case law from exit to give some ideas on what is meant. So if you're talking about a case that is manifestly without legal merit or manifestly outside the jurisdiction of the tribunal, there are probably 3 general points that you should consider. Let me just move this away. Can you see the wording? All right, do you see the wording now? Okay, of Article Rule 29 of the SIAC rules. So basically there are 3 points to consider. One is that you can apply for that if your objection on the claim or the defense goes either to the jurisdiction of the tribunal or to the merits. The second point to note is that your objection must really be a legal impediment to the claim. It must be on legal grounds. If you require a lot of witness statements and if you require examination of witnesses, then this is not a case for early dismissal. So it must be a legal point that would be a knockout blow. But of course, although the tribunal will assume all facts to be true as alleged, it doesn't mean that the tribunal has to be so unrealistic as to accept allegations which are totally incredible, frivolous, and just cannot be accepted by any degree of common sense. So I think that there must be a dose of reality in the facts that you assume to be true. And the third point is that the legal point or the knockout blow must be very clear and obvious. So again, bearing in mind that this is a time and cost-saving device, if you have to jump through hoops to prove the point, or again, you may have controversies over what happens or the context, for example, even on interpretation, then you may find that this would not be a case that can be disposed of summarily. So these are 3 basic points. And after SIC introduced this, in the 2017 version of the SIAC investment arbitration rules, there is also a provision for summary dismissal, which is not surprising given that the idea for the summary dismissal came from investor-state disputes under the exit rules. So when SIAC introduced the investment arbitration rules in 2017, they produced a set of rules that also provide for early dismissal. The difference is that they added an additional ground, which is where the claim or defense is manifestly inadmissible. Now, there might be some overlap between the meaning of an inadmissible claim and a claim that falls outside the jurisdiction of the tribunal. But this additional ground can also be found in the Stockholm Chamber of Commerce rules, which have also adopted this. And SIAC itself has provided for early dismissal in its investment arbitration rules in the later part of 2017. And again, SIAC's rules are quite familiar because it provides that the tribunal may dismiss a claim or counterclaim on the basis that it's manifestly without legal merit or manifestly outside the jurisdiction of the arbitral tribunal. So that is a broad overview, and perhaps I shouldn't take up too much time, so I will stop here and then pass the baton back to our chairman. I think we have some practical examples from maybe Arthur or Legion.
Well, thank you very much, Ling San. Yes, time is catching up on us. So I draw from your sharing with us, Ling San, that we got Article 20, Rule 29, really from ICSID, and here's where probably we can benefit, from Arthur. You have had dealings in cases on the ICSID rules. Would you like to share with us very quickly some of the experiences you've had?
I think probably you are asking me to talk about the case.
Okay, Li Jin, if you could quickly share with us, and then we'll move over to
1 minute. I can deal with that within 1 minute. I handled this case, Anson versus China, on behalf of our government. In that case, because Anson is a Korean company, the Korea and the China BIT require that any investment dispute need to be lodged by the investor within 3 years from the incurrence of the dispute. In that case, Anson happened to file their case after 3 years has lapsed. So it is for this reason we, on behalf of our government, seek early dismissal of the case based on Article 41.5 of the ICSID rules, arguing that there is manifestly, the case is manifestly without merit. And after 1-day hearing in Maxwell Chambers, the tribunal, which consists of 3 prominent arbitrators, they decide that our submission is accepted, and claimants' claims are dismissed in entirety. My understanding is that there has been over 20 cases in which the respondent, the state, has been seeking early dismissal of the dispute. And most of the cases, the tribunal only grant dismissal in part. And our case was one of the 2 cases in which the tribunal dismissed the case entirely. I'm just talking about that experience. Thank you.
Okay, Li Jin, thank you very much. Yeah, Arthur, do you have anything to add to that?
Yeah, I may very quickly share the cases before SIAC in 2017. Okay. That's shortly after the new rules was adopted. In that case, we represented the Chinese claimant, buyer of the commodities. The respondent was from South Africa. That the respondent put forward 2 points of defense, and we replied. Representing the claimant, applied for early dismissal of the 2 points of defense. One is that the respondent said that the case was already settled totally, without any more disputes. Second is that the respondent said that there's a common mistake about the contract. So after we applied for early dismissal, we partly was supported. The tribunal granted early dismissal to the first point, but the second point was not granted. And the takeaway from that case is that the tribunal, in examining that application for early dismissal, may make a decision with only the undisputed facts. If there's complicated facts issues, so the tribunal may be hesitating to make a decision on the early dismissal. Second is that I may share with the difference between the ICSID mechanism and the SIAC mechanism, that at the ICSID 41, Rules 41, there's a time limitation that the party may apply for early dismissal within 30 days after the tribunal was constituted. But at SIAC rules, there's no such kind of limitation. But the tribunal has a discretion to make a decision whether the party could proceed for that application. So very quickly, I share this experience of early dismissal case before SIAC in 2017. Yeah, thank you, Wei Ming.
Well, thank you very much, Arthur, and for those points as well. Well, ladies and gentlemen, believe it or not, time has finally caught up with us, and I can only say at this point in time that any further attempts by me to stretch this session for any much longer will be utterly and completely frustrated by the lack of time. So I would like you to join me in thanking my panelists, the distinguished panel, Chao Li Jin and Arthur Dong, Hee Teng Fong, Chan Ling San, and Simon Chapman. And thank you, gentlemen, for preparing for this webinar this afternoon and spending time with all of us. And for those of you who have sent in your questions, we will respond to those questions. We will be working with SIAC to see how we can get those questions out the answers out to all of you. And some of you have also asked how whether you could get hold of the presentation slides shared this afternoon. We are pleased to inform you that we will make that available as well. So we will make arrangements with SIAC to get those materials over to you as well. And so once again, thank you to all our panelists. Thank you to the over 600 participants who are still with us at the end of this webinar. Take care, ladies and gentlemen. All the best to all of you, and all the best. Good night. Good afternoon. Bye-bye.
Thank you.
Bye-bye.
Thank you.
Bye.